the Constitution Project for bringing this together, and Cravath for hosting it. So I'm going to talk about the closure or the non-closure of Guantanamo, how we got to where we are now, and what it looks like going forward in terms of some of the big issues. As Mason indicated, we are, I think, now, as a country, much further from closing Guantanamo than we were 2 years ago when President Obama issued his executive order to close the prison. I should add, though, that President Obama's order did not indicate that a clarity in terms of his Guantanamo policy, and that although the Obama administration had announced that it was going to close the prison, as time passed, it became clear that the administration was going to retain some of the main features of Guantanamo, in particular the use of military commissions and also indefinite detention or detention without charge. Those practices would be reformed. New legislation was passed improving commission procedures, and the administration took a more nuanced and moderate view of its indefinite detention power, one that took account of international law and also rejected unilateral executive power. Nonetheless, the promise to close Guantanamo in some respects was physical closure of the prison, but only a reform and not an end of the policies that underlay Guantanamo. In any event, President Obama's plan to close Guantanamo was quickly taken over by political events and what is an increasingly fierce political backlash on the Hill. In 2009, Congress passed legislation that blocked the resettlement of Guantanamo detainees in the U.S., including those detainees who had been either cleared for release by the administration or those detainees who had been ordered release by a federal court. This complicated the efforts to close Guantanamo for obvious reasons. The closure policy depended on other countries accepting some Guantanamo detainees for resettlement, but if the United States was clear it wasn't going to accept any, it complicated diplomatic efforts to try to resettle detainees. The most recent restrictions that were passed as part of the National Defense Authorization Act in December are even more draconian and have really made the closure of Guantanamo a dead letter for the time being. In addition to blocking the transfer or the resettlement of Guantanamo detainees in the U.S., it blocks the transfer is now blocked to the United States of Guantanamo detainees even to be incarcerated in a federal prison. And as Mason mentioned, the future trial, criminal trial of any Guantanamo detainee is now prevented. So at least with the current law says that you can't use any Defense Department funds to bring any Guantanamo detainee to the United States for any purpose, including for criminal prosecution. In addition, there are restrictions on the executive's ability to transfer Guantanamo detainees, or at least those detainees who haven't been ordered released by a court, and there's a cumbersome process that has to be gone through, which includes the Defense Secretary from certifying that the detainee is not going to be transferred to a country where any other detainee has engaged in recidivist terrorist activity, a term that's been used quite broadly. Finally, there's another proposal that would really be the final nail in the coffin of any possible closure for the future, which would not only bar the use of Defense Department funds for resettling, for bringing detainees to the U.S., but any federal funds whatsoever. So it would eliminate any room the Obama administration had to maneuver around the language of the December 2010 Act. So where are we in terms of the status of detainees? Well, there are 172 detainees remaining at Guantanamo. 47 of them have been slated for indefinite detention. This was the product of the Obama administration's task force that he appointed following his inauguration, and that conducted a review of all of the detainee cases. So these are individuals who, in short, the administration views as too difficult to try, too dangerous to release. So the position of the government is that they can be held indefinitely as part of, consistent with the laws of war. The second group of detainees, who number approximately 44, who the administration said should be tried. Those detainees can be tried by, or the original idea was that some would be tried by military commissions, other by federal courts. Only one detainee was actually prosecuted in a federal court. That was right here in New York. That was Ahmed Gailani, who was partly responsible for the 1998 embassy bombings, was tried before Judge Kaplan and convicted and sentenced to life imprisonment earlier this year. However, given the legislation, there look like there are not going to be any more criminal trials. So any individuals in that group, if they're going to be tried at all, will be tried by military commissions, which appear to be not just starting up, but gaining momentum at Guantanamo. And then the final group consists of 89 individuals who have been cleared for release. These individuals who the administration has said should be released from Guantanamo. However, that number includes 58 detainees from Yemen. And the administration, following the attempted Christmas Day bombing attack of a year ago, suspended all transfers to Yemen. So those 58 individuals are in a state of legal limbo, along with 31 other individuals who the administration has cleared but's not yet been able to transfer. These political developments have been going on against the backdrop of the habeas corpus litigation. In June 2008, the Supreme Court issued its third and most important Guantanamo detainee decision. The case was Boumediene versus Bush, and the Supreme Court ruled by a 5-4 vote that the detainees have a constitutional right to habeas corpus and an invalidated congressional legislation that repealed their right to habeas corpus. Of these cases, so basically what Boumediene meant was that these detainee cases would then go forward in the district courts, and the detainees would have a judicial hearing. The contours of that hearing were left explicitly to the district court to fashion, but the idea was that the detainee would have a meaningful opportunity to present a case before a judge and to rebut the allegations against him. Of these cases that have been going forward since the June 2008 Supreme Court decision, 58 cases have been decided. In 37 of those cases, the district judges have found no lawful basis for detention. 21 cases, district judges have upheld detention. These cases are now working their way up through the Court of Appeals. I would say two things about this. I think that the right to habeas review that Boumediene promised is being severely compromised right now by decisions of the D.C. Circuit. The numbers of habeas grants are declining because of standards that the D.C. Circuit is reading into the habeas process, which effectively means that it's a very, very low standard for the government. Effectively, the D.C. Circuit is reading the government's burden as only one of some evidence that it's a very low burden, and that the detainee effectively has to win his case now, not just before the district judge, but before the D.C. Circuit. In addition, the D.C. Circuit has cut off the federal district judges' remedial powers. It's ruled that the district judges, when they find there's no lawful basis for detention, have said that they can't grant any remedy. They can't order the release of the detainee. The Supreme Court has yet to intervene. So both in terms of the review of the detention and the ability to grant a remedy, core of the habeas corpus power, core of the judicial power, these are being compromised by the D.C. Circuit. Finally, as I'm running out of time, I want to just quickly mention the executive order, which is going to be discussed later. The Obama administration has announced, or it's been reported, that they're going to issue an executive order that will provide for some further review of detainee cases. Now, this applies to those detainees in particular who've lost their habeas cases. So that is, they've lost their habeas cases. They're basically slated for indefinite, arguably permanent detention without any further recourse. So the executive order is designed to provide some additional executive branch review of their cases. What impact this will have on the district court litigation remains to be seen. A lot of the details, or all of the details really, of the executive review process have yet to been hammered out. Hopefully it will result in close scrutiny of the detainee cases, but I should add, ultimately it's an executive branch process, and it's unclear how much, if any, effect effect this will have. So just to conclude, I think, again, we're further from closing Guantanamo than when we were in 2008, and many of the features of Guantanamo have become institutionalized. They've become more permanent. They've become more immune from challenge. And in my mind, one of the main questions is whether a lot of what we've seen at Guantanamo is going to remain at Guantanamo or is going to spread and become part of a larger detention apparatus.